Very good evening to all the participants. Today we would like to cover Companies Act, and let us see how much we can cover Companies Act or Partnership Act and what else we can cover. And then we can have a class on Sunday. So we will try to cover the balance or right laws. So this PPT, I think I've already shared, or I'll share. Just now I'll share. Let me share it also.
In progress.
So this PPT I am sharing in the chat box with you.
Good evening all.
Good evening.
सॉरी सर थोड़ा लेट हो गया वो
नहीं,
there was a call going on.
हो जाएगी वो अपने आप हो जाएगी। हाँ जी, हाँ। तो
विवेक जी आपके बिना मन ही नहीं लग रहा था।
सर वो क्या
अब हम स्टार्ट करेंगे।
अरे सर थैंक यू सो मच। ऑफिस चल रहा है सर पैरेलली वो कॉल्स पे कॉल शेट्टी साहब की क्लास में भी जब था तो 2 दिन कॉल आ रही थी मैं पहले उनको निपटा दूं।
सर ये किस में भेजा सर आप उसको शेयर किए अपने करंट ग्रुप में भेजे सर जिसमें लिंक भेजते हैं या
ये चैट बॉक्स में अभी जा रही है मेरे ख्याल अब चली गई होगी पीपीटी जा रही है अभी। हाँ थोड़ा टाइम लग रहा है। ये क्या है? अच्छा गई नहीं फाइल कुड नॉट बी सेंट।
It contains how many pages, sir?
कोई बात नहीं बाद में भेज दूंगा कोई इशू नहीं। हाँ जी तो आई थिंक लेट अस स्टार्ट दिस सेशन है ना पहले काफी देर हो चुकी है। सो प्राइवेट प्लेसमेंट नाउ दिस प्राइवेट प्लेसमेंट what is this actually? Prospectus. So first thing in the Companies Act which we want to discuss is prospectus. So this prospectus is required for initial public offering, offer for sale by certain members, and further issue of shares to public. So in all these cases, whether it is an IPO or offer for sale or further issue of shares to public, prospectus is required. And before issue of the prospectus, we have to file it with the ROC along with all attachments. So this is the actually PPT, which is very small, and I think it covers main provisions. But I'll share a detailed PPT also with you, which you can also go through. Besides that, I will share with you the earlier recordings also, because those are very detailed recordings. On each act, there is a lecture of 1 to 2 hours. So before issue of the prospectus, you have to file it with the ROC along with all the attachments. And validity of this is 90 days. So whenever you file it with the ROC, so within 90 days, you have to issue the prospectus. This public offer of securities is to be issued in demat form only. Then these two concepts of this red herring prospectus and shelf prospectus, these are very important concepts. So what is this red herring prospectus? So this red herring prospectus is basically in the nature of a prospectus which contains the minimum details of the prospectus. You have to file it with ROC at least 3 days before the public issue, and any variation between the red herring prospectus and final prospectus needs to be highlighted. And then you have to file the final prospectus with the ROC and SEBI, giving the details of the capital raised, quantum, closing price, etc. Another concept is regarding this shelf prospectus. Validity is 1 year from the first offer. So within a period of 1 year, whatever securities you issue, those are covered by the shelf prospectus. And whenever there is any subsequent issue, so you have to give a copy of the shelf prospectus plus this information memorandum.
In progress.
Which gives the now regarding this private placement.
Sir, small session, sir.
Yes, please.
This shelf prospectus can be issued only by banks and financial institutions.
Okay. Okay, great.
Normal companies cannot give this shelf prospectus.
Okay. Great. Now private placement. This offer is to be made to group of persons, maximum 50, excluding qualified institutional buyers and employees. But if we see the rules, so rules say 200 persons maximum, you can make this private placement to 200 persons in a financial year in the aggregate.
This is including 50 plus QIB plus employee, 200.
No. That is extra.
No.
That is extra.
Okay, 50 can be 200 in some case.
In the aggregate in a financial year. In the act, they say 50 or whatever is prescribed. And what is prescribed is 200 as per rules. Rule 14, if you see, of prospectus and allotment of securities, then it says 200. That is extra, of course, this excluding qualified institutional buyers and employees.
If any question is coming on this, the offer to be made to the group of persons, maximum 50. So private is
one
only
of
50, sir. Private, you told earlier it is only 50.
50 at a time, 200 aggregate in the financial.
But
So
actually,
50
the basic thing, if it exceeds 200, it will become public issue.
Yes.
That's why they have restricted to maximum 200.
Sir, earlier the lectures is only 50 in a year, in 1 year, only 50 maximum.
200 is there, sir. Now 200 is there.
Actually, in the act, they have written 50 or whatever may be prescribed. If we see the act, what it says, just a minute. ये तो पहले डिस्कस हो चुका है आपसे तविंदर पाल जी।
हाँ जी सर।
ये डिस्कस तो हो गया था आपसे।
अच्छा
भाई एक्ट में लिखा है 50 और व्हाटएवर में भी प्रेस्क्राइब्ड, ठीक है,
right.
लिखा है वहां लिखा है, रूल्स में लिखा है 200, बस यही है।
राइट।
Now if first private placement is pending, then second private placement is not allowed unless first private placement is closed. ये भी एक point है. And number of applicant is increased, then part 1 applies. ठीक है. No right of renunciation is allowed. So this placement is made to specific persons and he cannot renounce this right in favor of any other person. Otherwise तो public issue हो जाएगा ना फिर. And money will be allowed to be used only after the allotment of securities. और अलॉटमेंट में भी है कि पहले क्या होता था, अदरवाइज शेयर एप्लीकेशन मनी में पैसा पड़ा रहता था, तो ये कहते हैं कि अलॉटमेंट शुड बी डन विद इन 60 days और यू हैव टू रिफंड द मनी इन नेक्स्ट 15 days. And if you do not refund the money, then you have to pay interest at the rate of 12% per annum. No advertisement or publication is allowed, and you have to file form with ROC within 15 days of allotment. Now,
separate account.
हाँ जी, हाँ बोलिए
For
बोलिए.
application you have to open a separate account.
Yes. हम इसीलिए ना बेसिक चीजें यहाँ पर कवर कर रहे हैं, बहुत ज्यादा फिर डिटेल में हो जाएगा, है ना. हम चाहते हैं एक बार ना एक ओवरव्यू ले लें कंपनीज एक्ट का, ठीक है ना.
ओके सर,
वो इम्पोर्टेंट है. तो उसके बाद वो क्या करेंगे, फिर हम डिटेल में, तो आपको बहुत कुछ दे रखा है हमने क्या है, हर एक सेक्शन पर क्वेश्चन बना रखा है.
अच्छा जी, हाँ वो देखा था मैंने, वो 1500-1600 पेज का.
हाँ बस हाँ वही, हाँ वो पूरा डिटेल में है फिर.
जी
हाँ उसको डिस्कस करेंगे, यहाँ तो फिर कुछ भी नहीं डिस्कस हो पाएगा ना, बात ये है.
एग्रीड सर.
तो हम आज बेसिकली एक स्केच डिस्कस कर रहे हैं कंपनी एक्ट का, आप ऐसा समझ लीजिए.
राइट.
तो शेयर कैपिटल में क्या है, 2 टाइप्स ऑफ शेयर कैपिटल आर देयर. इक्विटी कैपिटल विद सेम वोटिंग राइट्स विद वेरिएशन ऑफ वोटिंग राइट्स. सो कैन देयर बी इशू ऑफ इक्विटी शेयर्स विद वेरिएशन ऑफ वोटिंग राइट्स? द आंसर इज यस. ठीक है, ऐसा नहीं कि सिर्फ प्रेफरेंस में ही हो सकता है, तो इक्विटी शेयर्स में भी विद वेरिएशन ऑफ वोटिंग राइट्स हो सकता है. देन प्रेफरेंस शेयर्स, और प्रेफरेंस शेयर्स जो है ऐसे कभी भी इरिडीमेबल नहीं हो सकते. सो दीज आर ऑलवेज रिडीमेबल और कंपल्सरीली कन्वर्टेबल. अदरवाइज क्या होगा, ये तो लोन की शेप में हो जाएगा ना फिर. तो इसीलिए कहते हैं कि दीज आर टू बी ऑलवेज रिडीम्ड और दे आर कंपल्सरीली कन्वर्टेबल इनटू इक्विटी शेयर्स. और मैक्सिमम पीरियड नॉर्मल केस में 20 ईयर्स है इनका, और 30 ईयर्स है इन केस ऑफ इंफ्रास्ट्रक्चर प्रोजेक्ट्स. ठीक है. एंड दे हैव गॉट प्रेफरेंशियल राइट्स ड्यूरिंग वाइंडिंग अप और लिक्विडेशन. अगर हम अपना 53 भी देखें, सेक्शन 53, तो सेक्शन 53 में भी प्रेफरेंस शेयर होल्डर्स कम अबव द इक्विटी shares.
Yes.
Okay. And if dividend is not paid for 2 or more years for these preference shareholders, then they are entitled to vote in all matters. Okay. Otherwise, they can vote on resolutions which directly affect their interest. For issue of shares with differential voting rights, what is required? 3/4 of the consent or special resolution is to be passed. Okay. Whose rights are affected? Then 3/4 consent of that class is also required. Okay. Now suppose with 3/4 consent or special resolution, a resolution is passed which affects the different classes. So then how many can object to it? So not less than 10% of the holders of such class, they may disagree. So they can apply to the NCLT within 21 days and such variation shall not be permitted till order is passed by the NCLT. Okay. And whatever order is passed, it is binding on all and such order is to be filed with ROC within 30 days of passing of the order. Now registration of charge. Form is to be filed within 30 days of the charge created. CHG1 formation uske liye, hai na? Another 30 days is allowed with additional fees. And after such period, application is to be filed with ROC and they may permit with another 60 days with ad valorem fees. Okay. ROC thereafter will issue certificate of charge in CHG2 and CHG3. If charge is not created, liquidator can still consider the same. If company fails to create charge, then the person in whose favor charge is created can file with ROC in such manner with such fees. Okay. So suppose the company, there was a charge which was created by the company, but the company did not file it with the ROC. So then the person in whose favor the charge is created, he can directly file it with the ROC. Okay. And ROC will issue notice for the same, and if no reply is received within 14 days, then ROC will register the charge. Okay. Regarding satisfaction of charge also, same procedure of this 30 days plus 30 days with additional fees is to be followed. Okay. And ROC will issue notice for confirmation and 14 days if form is signed by both, then no notices. Regarding annual return, थोड़ा एक स्केच ले लेते हैं, ओवरऑल स्केच ले लेते हैं कंपनी एक्ट का है क्या चीज, ठीक है ना, क्योंकि कुछ ना कुछ क्वेश्चंस इसमें से आ जाएंगे। एनुअल रिटर्न क्या है? एनुअल रिटर्न इज रिक्वायर्ड टू बी फाइल्ड within 60 days of the annual general meeting. Now suppose no AGM is held, ठीक है, then you have to file the annual return with statement specifying reasons for not holding AGM. ठीक है, within 60 days of AGM would have been held. ठीक है, जब आपका 60 days का पीरियड हो गया तो आपको क्या करना है, एक एनुअल रिटर्न फाइल करनी है विद स्टेटमेंट स्पेसिफाइंग रीजंस व्हाई द एजीएम वाज नॉट हेल्ड। ठीक है, कोई है मतलब जिसको कहते हैं क्या, देयर इज सम से डिसएग्रीमेंट बिटवीन द मैनेजमेंट, है ना, इस तरह से। If listed company or company having paid up share capital of 10 crore rupees or turnover is of 50 crores, then annual return is to be certified by a practicing company secretary also. ठीक है, and this extract of annual return shall form part of the director's report. ठीक है, regarding
Sir, a small session, sir.
yes please.
Now this extract of annual return shall form part of director's report is removed, sir. This was removed.
Okay.
Actually, this was removed. If the company is having website,
सेक्शन कौन सा है, एक मिनट सेक्शन बताएंगे मेरे को?
this 90, that section itself, sir, 92 or 92, I think.
92, just a minute.
That MGT 9 is withdrawn by MCA.
Okay.
We'll share in the group, sir. Otherwise, we'll share in the
ठीक है,
group.
ठीक है, ठीक है, तो we should remove this extract of annual return.
Yeah, you can remove.
Okay, great. ठीक है, ग्रुप में शेयर कर दीजिएगा।
Okay, sir. Okay.
और ये जो अकाउंट्स हैं, अकाउंट्स आर टू बी रिक्वायर्ड टू बी फाइल्ड विद आरओसी विद इन 30 days of the AGM. If not adopted, then in 30 days of the adjourned AGM with additional fees. ठीक है, and if no AGM is held, then you have to file the accounts with statements specifying reasons for not holding AGM within 30 days of AGM would have been held. ठीक है, जब होनी थी, जो ड्यू डेट थी उसकी, उसके within 30 days you have to file it. ठीक है. And if there are some consolidated accounts, if there are some foreign subsidiaries, ठीक है, तो but they may not be required to be audited, तो उनकी फिर provisional statement या जो भी statement आपके पास available है, you have to consolidate them. ठीक है. Consolidated accounts are also required to be filed. Now regarding this AGM, every year AGM should be held. First AGM you have to hold within 9 months of the financial year end, and subsequently every year you have to hold within 6 months. Okay. And there cannot be a gap of more than 15 months between two AGMs. Extension may be allowed for valid reason. Maximum period is 3 months. Timing क्या है आपका? 9 AM to 6 PM other than national holiday within same city, village or town. ठीक है. Now regarding this unlisted company, they can hold anywhere with prior approval of all shareholders in electronic. Okay. So if they want to hold it other than in the same city, village or town, so they have to get the approval of all the shareholders, so they can hold it anywhere. And if there is any default of holding share AGM, then members can make application to the tribunal, and tribunal will give direction to hold, and one member in person or proxy will constitute the meeting. Regarding this extraordinary general meeting, so company can convene at any time for special reason as it deems fit. Okay. And who can request? So members having 1/10 of the paid up share capital can request to the board of directors along with reasons for calling extraordinary general meeting, duly signed and send it to the registered office. Now board may or may not react. So if board does not act within 21 days and maximum 45 days to convene extraordinary general meeting. If they fail, then requisitionist can convene within 3 months of the requisition date, and expenses incurred on this convening this meeting will be reimbursed from the company. Okay. And if quorum is not present in the meeting, then the meeting shall stand cancelled. Now, what is the quorum for the general body meeting? In case of public limited company, if the members of the company is less than 1000 members, you have to count as per the members register. Okay. 5 members personally present. Members of the company is 1000 or more, but less than 5000. So 15 members present. Members of the company is more than 5000, then 30 members present.
It is up to 1000, na sir? First one
less
is
than 1000.
less than 1000. So here where will go 1000 then?
एक मिनट देख लेते हैं अभी. अकाउंट कंपनी राम कृष्णा जी.
Coming, sir. Coming. I also forgot it.
हाँ.
श्याम कृष्णा जी को सेक्शन बड़े अच्छे से याद है.
हाँ.
Sir, up to 1000, sir, actually.
up to 1000 है ना. ठीक है.
First is
Yes,
up to
yes.
1000, yes.
ठीक है. तो ये हो जाएगा आपका is up to 1000.
Less than की जगह up to हो
Up
जाएगा.
to 1000, more than, up to 5000.
हाँ. इसको
Simple 5, 15, 30.
हाँ. तो ये हो जाएगा आपका is
वो ये ठीक है सर. बाद में जो less than
हाँ more
5000,
than 1000. ठीक है. हाँ.
more than 1000 up to 5000.
हाँ, ये up to 5000 होता है. ठीक है. और ये more than 5000. ठीक है. थैंक यू. तो इसमें करना क्या है आपको? ये 5 मेंबर्स, 15 मेंबर्स और 30 मेंबर्स. प्राइवेट लिमिटेड कंपनी में क्या कोरम है आपका? 2 मेंबर्स प्रेजेंट. ठीक है. एंड इफ कोरम इज नॉट प्रेजेंट इन हाफ एन आवर, देन द मीटिंग शैल स्टैंड adjourned and it may be convened on the next week on the same day and same time or at any other date or time. ठीक है. And in adjourned meeting also, if quorum is not present within half an hour, then the members present will form the quorum. ठीक है. जितने भी मेंबर होंगे वही quorum मान लिया जाएगा.
Small suggestion, sir.
Yes, please.
Members present in person, that will be the quorum.
Yes.
Maybe they may confuse in exam.
Yes.
Members present in person.
हाँ, प्रेजेंट इन पर्सन है. ठीक है. ये सभी के साथ है.
Yes, sir.
Proxies will not be counted for the purpose of quorum actually.
इन पर्सन. ठीक है. ये हो गया. ओके. नाउ रिगार्डिंग दिस कॉर्पोरेट सोशल रिस्पॉन्सिबिलिटी. ये कॉर्पोरेट सोशल रिस्पॉन्सिबिलिटी में क्या है कॉन्सेप्ट? जस्ट अ मिनट. ये कॉर्पोरेट सोशल रिस्पॉन्सिबिलिटी में ये है कि कंपनी विच आर दी कंपनीज कवर्ड, ठीक है। नेटवर्थ आनी है आपकी 500 करोड़ रुपीज और मोर, ठीक है। टर्नओवर ऑफ 1000 करोड़ और मोर, और नेट प्रॉफिट ऑफ 5 करोड़ और मोर ड्यूरिंग इमीडिएटली प्रीसीडिंग फाइनेंशियल ईयर। तो दीज आर दी कंपनीज कवर्ड, ठीक है। और जो CSR कमेटी ऑफ द बोर्ड है, दैट शैल कंसिस्ट ऑफ 3 और मोर डायरेक्टर्स, एंड एट लीस्ट 1 डायरेक्टर शैल बी इंडिपेंडेंट डायरेक्टर. And what is required to be spent? At least 2% of the average net profits made during the 3 immediately preceding financial years. Or where this
small
money is to
suggestion,
be
sir.
spent? Yes, please.
Unlisted company with 2 or more director, you are saying, no? Unlisted company with 2 or more director.
हाँ.
Even a public unlisted company where it is required to appoint independent directors, then independent director should be there. I think after unlisted company, you can write in bracket. If there is no requirement of independent directors, you can write.
Okay. And where to spend this money? It is to be spent on projects or programs relating to activities specified in Schedule 7. अच्छा, यू आर सेइंग कि भाई इसमें भी आपको एक इंडिपेंडेंट डायरेक्टर होना चाहिए ना?
हाँ, yes sir. Where there is no requirement of independent directors, then 2 directors are enough.
Okay. Now regarding this registered valuer. Registered valuer के केस में क्या है कि valuation is required for a property, shares, securities, stock, debentures, goodwill, net worth, etc. ठीक है। और there is a requirement of this qualification, experience and this registered valuer, ठीक है। It has to be appointment has to be by the audit committee, and in absence of audit committee, it has to be done by the board of directors, ठीक है। तो valuer shall be impartial. He will do true and fair valuation, and he will exercise due diligence while performing his function. Valuation should be as per the rules prescribed. Okay. He should not have any direct or indirect interest. 3 years prior to the appointment and 3 years after the completion of assignment. If there is a contravention of any provision, then penalty of 25,000 to 1 lakh rupees is there. And if there is an intention to fraud the company or members, then there is imprisonment of 1 year and fine of 1 lakh to 5 lakhs. And where if it is convicted, then he has to refund the remuneration he has received, and he has to pay the damages to those who suffered due to his valuation. Now regarding this compromise arrangement or amalgamation. This compromise can be done with the creditor to forego some part of the amount due, or debenture holder they forego their unpaid interest, etc. Okay? So compromise means accepting something less than what is due. And arrangement means percentage of debt converts into equity of the company. This is arrangement. Amalgamation, merger or demerger. Amalgamation means 2 companies merge together. 2 companies amalgamate, 3rd company is formed. Merger means there are company A and B. So company A is merged into company B, or company B is merged into company A. And demerger means out of 1 company, more than 1 companies are formed. Now removal of name of the company from register of companies. ये जो amalgamation है, थोड़ा सा इस पे और डिटेल में कर लेते हैं। 1 मिनट आप थोड़ा टाइम दूसरी amalgamation, 1 मिनट। amalgamation पर इस बार क्वेश्चन भी आया था। एक तो ये पूछा था amalgamation में कि भाई when submitting a scheme to NCLT, ये प्रॉक्सी फॉर्म, प्रॉक्सी जो है वो वैलिड है या नहीं? Just a minute. ये compromise.
Today Yuvraj attempted, sir. He was saying amalgamation question for 8 marks have come.
हैं?
Today Yuvraj attended and cleared the exam.
हाँ. Yesterday.
Yesterday or today?
Yesterday.
Acha, he got this amalgamation for 8 marks.
हाँ. वो तो ऐसा ना, वी हैव डन ए केस स्टडी आल्सो, देयर इज अ रिकॉर्डिंग, उसको आप देख लीजिएगा.
Okay.
Separate classes there on amalgamation itself, and I've shared one case study also in the material. ये तो महासागर है ना एक्चुअली. आज थोड़ा एक स्केच ले लेते हैं, आइडिया ले लेते हैं कंपनीज एक्ट है क्या चीज, ठीक है ना. रिमूवल ऑफ, फिर कभी डिटेल में डिस्कस करेंगे, नहीं तो पहले फर्स्ट यू गो टू दोस वीडियो रिकॉर्डिंग्स और उसके बाद में फिर इसको डिस्कस कर लेंगे. रिमूवल ऑफ नेम ऑफ द कंपनी फ्रॉम रजिस्टर ऑफ कंपनीज, तो ये भी एक इंपॉर्टेंट प्रोविजन है. तो इफ रजिस्ट्रार हैज रीजनेबल कॉज टू बिलीव दैट द बिजनेस हैज नॉट बीन कमेंस्ड विद इन 1 year of its incorporation, or if the company is not carrying on any business during the immediately preceding 2 years, or the subscribers have not paid the subscription money and declaration is not filed within 180 days, after physical verification it is revealed that the company is not carrying on any business, then show cause notice will be issued to the company and all directors for removal of name and request to file representation within 30 days of notice as to why their name should not be removed. ठीक है. अब कंपनी अपने आप को ही, सपोज दे वांट टू रिमूव द नेम, ठीक है, देन दे हैव टू पास द स्पेशल रेजोल्यूशन, और they have to obtain consent of the 75% of the members after extinguishment of all liabilities. So they can file application as per the above grounds, and registrar will cause public notice to be issued, and if company is regulated by any special act, then permission of such regulatory authority is also required. Now this subsection 2 is not applicable to section 8 company. So for section 8 company, the company itself cannot apply for removal of the name. Only registrar can remove the name. On the expiry of the show cause notice time, if no reply is received or no contrary is shown, then registrar will remove the name from the register of members and publish in official gazette that the company stands dissolved. After removal of name, if liability is pending, then the company should ensure there are sufficient assets or there is sufficient provision to meet such liabilities. And the liability of the director, manager or any officer will continue as if the company is not dissolved. So they will be personally liable, and nothing will affect the power of the tribunal to wind up the company even after the name of the company is removed. Now section 249, restriction to make application. So there are certain situations where you cannot move an application to remove your name. What are those restrictions? If you have changed your name or you have shifted your residence office from one state to another, if you have disposed of the property or interest therein before discontinuance of business, for disposal of gain in ordinary trading, you have made application to tribunal for compromise or arrangement, or the company is to be bound as per the act or IBC. So in those situations, you cannot make an application for removal of your name. Okay. If there is any violation of above provision while filing application under section 248(2) on your own, then fine is extended to 1 lakh. Fine may extend to 1 lakh. Section 251 talks of fraudulent application. If an application is filed by the company under section 248(2) to defraud or deceive any creditor or any person or to evade any liabilities, then it is punishable under section 447, and registrar will recommend prosecution of the directors also.
Sir, here one related question was there, sir. If
Yes.
the office is transferred from one state to another state of a company, then who is empowered to do it, sir? So the options were Supreme Court, NCLT, High Court, or fourth option was the registered office is removed from one state to another state.
हाँ.
Who is authorized to give this change of
The regional director, sir. Sir, the regional director concerned.
Actually, you cannot make an application within 3 months. 3 months के बाद तो आप एप्लीकेशन मूव कर सकते हो. भाई ये नहीं ना आपने अभी इस ऑफिस से, क्योंकि पब्लिक नोटिस जाता है इसमें, अब मान लीजिए आपने एक स्टेट से दूसरे स्टेट में ऑफिस मूव किया और आप रिमूवल ऑफ नेम्स के लिए अप्लाई कर रहे हो इमीडिएटली, तो दैट इज नॉट परमिटेड।
Okay, so who is authorized to do it? This is my question. This change
Change
of
of-
state.
ये तो एक्चुअली
जी
क्या
सर,
होता है, सेंट्रल गवर्नमेंट के पास पावर है, सेंट्रल गवर्नमेंट ने डेलीगेट कर दी रीजनल डायरेक्टर को।
रीजनल डायरेक्टर।
Regional director. Okay.
Now appeal to tribunal under section 252. Any aggrieved person by order of the ROC for the company dissolved, so he may file an appeal within 3 years of the order. ठीक है? And if the tribunal feels that removal of name is not justified, then it will pass the order to ROC to restore the name of the company. And before passing the order, opportunity of being heard should be given to the company, ROC and the concerned person. ठीक है? Registrar can also file the application within 3 years if found that due to mistake or on the basis of incorrect information given on consequent to that name was removed. ठीक है? Order passed by tribunal required to be filed with ROC within 30 days and ROC will issue fresh certificate of incorporation. ठीक है?
Sir, here there is a change, sir.
हाँ जी,
This is appeal is 3 years and application is a very long period, 30 years or something, sir.
तो वो तो आ रहा है ना आगे।
नहीं, इसी में है सर, वो अपील एंड एप्लीकेशन है ना सर ये।
हाँ,
Appeal is within 3 years and this application is I think 30 years, sir. This is what we have studied.
नहीं, इसमें 20 years तक हो सकती है इफ कंपनी मेंबर क्रेडिटर और एम्प्लॉय फील्स एग्रीड। सपोज इनकम टैक्स की कोई डिमांड आ गई, इनकम टैक्स और इनकम टैक्स एप्लीकेशन लगा सकता है ट्रिब्यूनल को, तो विद इन 20 years दैट नेम कैन बी रीइंस्टेटेड।
ये 20 है सर।
हम्म। So this company member, creditor or employee, if they feel aggrieved, so then they can make the application within 20 years of the order of publication in the official gazette. And if tribunal is satisfied that the company was carrying on business or operations, then it may order to restore name and issue direction that the name of the company had not been struck off from the register of companies. Section 408, central government by notification they have established tribunals. ठीक है, एनसीएलटी, एनसीएलटी। प्रेसिडेंट है, हु कैन बी द प्रेसिडेंट। ठीक है, प्रेसिडेंट के केस में एनसीएलटी में ही शुड बी जज ऑफ हाई कोर्ट ऑफ फॉर 5 years। ठीक है, और जुडिशियल मेंबर्स हैं, फिर टेक्निकल मेंबर्स हैं, इनकी अलग अलग क्वालिफिकेशन है, ये चार्ट में हमने दे रखी। ठीक है, टर्म ऑफ ऑफिस कितनी है, 5 years है एंड दे कैन बी रीअपॉइंटेड फॉर नेक्स्ट 5 years। मिनिमम कंप्लीटेड एज दोनों ईयर में 50 years है, और फॉर प्रेसिडेंट में 67 years है, फॉर मेंबर्स इट इज 65 years इन केस ऑफ ट्रिब्यूनल। ठीक है, और एपेलेट ट्रिब्यूनल्स में द अपॉइंटमेंट इज फॉर 5 years एंड दे कैन बी रीअपॉइंटेड फॉर नेक्स्ट 5 years, और मिनिमम कंप्लीटेड ईयर आपकी 50 years। फॉर चेयरपर्सन इट इज 70 years, फॉर मेंबर्स इट इज 67 years। रिमूवल ऑफ नेम, रिमूवल ऑफ मेंबर कैसे हो सकता है, ये हो सकता है एज पर द ऑर्डर्स ऑफ द सेंट्रल गवर्नमेंट ओनली। ठीक है, और इसमें भी जज होता है सुप्रीम कोर्ट या हाई कोर्ट का। तो क्या क्या ग्राउंड्स हैं, इफ ही इज एडजस्ड इंसॉल्वेंट, कन्विक्टेड ऑफ ऑफेंस इन्वॉल्विंग मॉरल टर्पिट्यूड, फिजिकली और मेंटली he has become incapable, he has acquired financial or other interest which will hinder their functioning, or he has abused his position। ठीक है,
Almost similar to removal of member
हाँ।
of IBBA.
हाँ, तो इसमें क्या है कि इन केस ऑफ B2E, its right of being heard will be there and he can be removed only by the order of the central government। Now regarding this appeal procedure and jurisdiction, तो section 421 में you can appeal to the appellate tribunal against the decision of the NCLT, और पीरियड कितना है, 45 days है, प्लस 45 days another is given। ठीक है, if NCLT passes the order with the consent of both parties, then no appeal can be given to NCLT। सेक्शन 423 बोलता है अपील टू सुप्रीम कोर्ट। ठीक है, तो अपील टू सुप्रीम कोर्ट में क्या है, 60 days प्लस 60 days।
60 days।
ओनली ऑन क्वेश्चन ऑफ लॉ यू कैन अपील टू सुप्रीम कोर्ट। सेक्शन 422 है डिस्पोजल इन अपीलेट ट्रिब्यूनल और सुप्रीम कोर्ट। ठीक है, सो विद इन 3 months एंड एक्सटेंशन इज मैक्सिमम 90 days। 424 में बोलता है कि एनसीएलटी एंड एनसीएलटी विल नॉट बी बाउंड बाय प्रोसीजर ऑफ सिविल कोड। ठीक है, इट शुड बी regulated based on the principles of natural justice। Civil court will not have jurisdiction to issue stay order or injunction order and limitation act will also apply। ठीक है, तो ये था ब्रीफ अबाउट कंपनीज एक्ट। अब एक बारी मैं आपको दूसरी पीपीटी भी दिखा देता हूँ। ये जो है ना, ये डिटेल्ड पीपीटी है हमारी, 1424 पेजेस की है ये, ठीक है ना। ये भी मैं आपके साथ शेयर कर दूंगा। और इसमें क्या है, हमने ना इसको सेक्शन वाइज फिर एनालाइज किया हुआ है। ये तो था ब्रीफ। देखो, जिसको थोड़ा पढ़ना है वो वहां से पढ़ लो, ज्यादा पढ़ना है डिटेल में यहां से पढ़ लो। चैप्टर वाइज है, चैप्टर वाइज भी सेक्शन वाइज है, एक एक, और सबकी रिकॉर्डिंग भी है। क्योंकि मान लो कुछ भी आइडिया नहीं है तो पहले यहां से पढ़ लो, इसको एक बार थोड़ा सा आइडिया हो जाएगा आपका बेसिक, फिर अब वहां से पढ़ लेना डिटेल में। अब ये तो देखो हमने कितनी जल्दी कर लिया इसको, कंपनी एक्ट को मोटा मोटा कर लिया ना, आधे घंटे के अंदर कवर कर लिया हमने। इससे कुछ तो समझ में आया ही होगा, और कुछ क्वेश्चंस भी आ गए होंगे इसमें, कुछ क्वेश्चंस इसी में से भी आ जाते हैं। बाकी डिटेल में तो फिर वहां से पढ़ सकते हैं, और उससे भी ज्यादा डिटेल तो फिर बेयर एक्ट से पढ़ सकते हैं, अलॉन्ग विद रूल्स। जो भी एक्ट आपको पढ़ना है अलॉन्ग विद रूल्स पढ़ना है। लिमिटेड लाइबिलिटी पार्टनरशिप एक्ट, लिमिटेड लाइबिलिटी पार्टनरशिप एक्ट में जो है, एक तो पॉइंट ये है कि दिस इंडियन पार्टनरशिप एक्ट डज नॉट अप्लाई टू एलएलपी, ठीक है। तो इट इज हाइब्रिड फॉर्म ऑफ पार्टनरशिप फॉर्म एंड प्राइवेट लिमिटेड कंपनी, इट इज ए कॉर्पोरेट पर्सन, ठीक है। ये तो हो ही गया हमारा। अब बॉडीज कॉर्पोरेट में क्या आ रहा है? बॉडीज कॉर्पोरेट में इट इंक्लूड्स कंपनी रजिस्टर्ड इन इंडिया और अब्रॉड, और एलएलपी रजिस्टर्ड इन इंडिया और अब्रॉड, ठीक है। एंड इट डज नॉट इंक्लूड कॉर्पोरेशन, कोऑपरेटिव सोसाइटी और एनी अदर बॉडी कॉर्पोरेट नोटिफाइड बाय सेंट्रल गवर्नमेंट इन ऑफिशियल गजट। ट्रिब्यूनल का मतलब यहाँ पर एनसीएलटी है, और एपेलेट ट्रिब्यूनल मींस एनसीएलटी। और फाइनेंशियल ईयर क्या है? फ्रॉम 1st day of April to 31st March. And any LLP incorporated on or before 30th September, then ensuing 31st March will be the year end. ठीक है। If incorporated after 30th September, then 31st day of the March of the year next following that year will be the financial. पार्टनर कौन कौन हो सकते हैं? एनी इंडिविजुअल और बॉडी कॉर्पोरेट। Following shall not be capable of becoming partner. कौन से? If you are of unsound mind, found by competent court and finding in force, ठीक है। Undischarged insolvent, applied to be adjudicated as insolvent and application is pending, then you cannot become a partner in an LLP. Minimum 2 partners है, maximum limit 10. Minimum number should not go below 2 for more than 6 months. Else, continuing partner shall be personally liable for the obligation of the LLP incurred during that period. ठीक है। डेजिग्नेटेड पार्टनर एक इंपॉर्टेंट कॉन्सेप्ट है इसमें। तो डेजिग्नेटेड पार्टनर क्या कहता है कि मिनिमम 2 डेजिग्नेटेड पार्टनर्स आर रिक्वायर्ड एंड बोथ शुड बी इंडिविजुअल एंड वन ऑफ देम शुड बी रेजिडेंट ऑफ इंडिया, ठीक है। नॉमिनी ऑफ बॉडी कॉर्पोरेट कैन एक्ट एज डेजिग्नेटेड पार्टनर. So one may become a designated partner by specifying so in the incorporation documents or LLP agreement. Concept of designated partner is must. So form plus consent plus prescribed fees is required to be filed within 30 days of the appointment or cessation. ठीक है। इसमें क्या होता है? डेजिग्नेटेड पिन होता है, जैसे उसमें डिन होता है, यहाँ पर डेजिग्नेटेड पिन है। And liability of designated partner is for all compliances and any penalty imposed on LLP, for that also he is liable. Any vacancy of designated partner shall be filled in 30 days, else all partners shall be deemed as designated partners. Incorporation and other related matters. ठीक है। So 2 or more persons associated for carrying on lawful business for profit. ठीक है। Incorporation documents में क्या क्या आएगा? Incorporation document में partners name and address आ जाएगा, फिर फॉर्म आ जाएंगे आपके पास, ठीक है। एड्रेस आ जाएगा, एड्रेस ऑफ रजिस्टर्ड ऑफिस, नेम ऑफ द एलएलपी, डेजिग्नेटेड पार्टनर डिटेल्स, और फिर प्रपोज्ड बिजनेस। तो पी एफ एंड बी, इस तरह से इसको याद कर सकते हो कि इनकॉर्पोरेशन डॉक्यूमेंट्स में क्या क्या आपको देना है, ठीक है। नाउ स्टेटमेंट इन द प्रेस्क्राइब्ड फॉर्म इज टू बी मेड स्टेटिंग दैट रिक्वायरमेंट्स ऑफ द एक्ट एंड रूल्स मेड देयर अंडर हैव बीन कंप्लाइड फॉर द इनकॉर्पोरेशन एंड मैटर्स incidental thereto. Such a statement should be made by any one of the advocate, CA, CS or cost accountant and one of the subscriber to the incorporation documents. LLP agreement should be filed within 30 days of incorporation of the LLP. Mutual rights and duties of partners and rights and duties in relation to LLP are governed by LLP agreement. So if it is silent, then there is one schedule 1, जैसे टेबल ए है कंपनी एक्ट में, तो यहाँ पर जो है शेड्यूल 1 है. Agreement made before incorporation, then it can be ratified by all the partners. If registrar is satisfied with all the above documents, then he can register and issue incorporation certificate under the official seal within 14 days. Schedules to the act. Schedule 1 में क्या है? Schedule 1 में basically एक it is related to mutual rights and duties of partners and rights and duties of partners with LLP. So this schedule is applicable in absence of agreement on the matters. अगर आपका LLP agreement है तो उससे गवर्न हो गए. अगर LLP agreement में कुछ चीज नहीं लिखी है तो Schedule 1 में देख लेंगे. Schedule 2 is related to conversion of partnership form into LLP. ठीक है. Schedule 3 है related to conversion of private limited company into LLP and Schedule 4 है related to conversion of unlisted public company into LLP. Now cessation of partnership interest. So if a person ceases to be a partner as per the provisions mentioned in the agreement or in the absence of such provision, not less than 30 days notice is to be given to other partners of his intention of doing so. Okay. So it can be done in the following cases: on his death or dissolution of the firm, if he is declared of unsound by competent court, or if he has applied to be adjudged as insolvent or is declared as insolvent. Now partner ceases to exist as a partner, but he is liable unless third party is aware of his cessation or notice is delivered to the registrar, and is liable for the old liabilities which were incurred during his tenure as partner, and he is entitled for the contribution made in the LLP and share of profit after reduction of accumulated losses, if any. Okay? And after cessation, he cannot interfere in the management of the LLP. Now registration of change of partner or their details. So any change in name or address or the change of the partner, then it is his duty to inform the LLP in 15 days. And LLP should inform the registrar within 30 days of admission or cessation of partner or change in information of partner of above such change. Okay. Now, if there is any contravention of this provision, then there is a liability. Partner can also file directly for cessation, and registrar will first try to take confirmation from LLP firm. And if no confirmation is received within 15 days, then ROC will register this change. Okay. Now, extent of liability of LLP partners holding out. So, any partner acting without the authority, he will be personally liable. Okay. LLP other partner is not liable for his acts. Any wrongful act or omission by any partner in the ordinary course of business, then LLP is liable. Any act or wrongful or omission by any partner, then other partner is not liable. Any obligation of LLP arises as per the contract, then LLP is liable. Liability of LLP shall be met out of the property of the LLP. Okay. And in case of personal liability, personally he will be liable. Personal partner will be liable. In case of holding out, the person is liable, and if any credit is availed by LLP, then to that extent LLP is also liable. After the death of partner, if his name is used, then deceased partner is not liable, or his legal representative is not liable. If business is carried out for the purpose of defrauding the creditors or any person or for fraudulent purpose, then LLP and partner who acted in such manner is liable for unlimited liability. If LLP proves that it was without the knowledge or authority of the LLP, then LLP will not be liable, and the person who is doing such fraudulent activity will be personally liable. If LLP partner or designated partner or employee conducted affairs in fraudulent manner, then they are liable to compensate the person who suffered and without prejudice of criminal proceeding. So here also LLP proves that if it was done without the knowledge of LLP, then it can be saved. Regarding maintenance of accounts, audit and filing, what it says. So you can maintain accounts either on cash or accrual basis, double entry system, and you have to maintain it at registered office for such period. What is the period? Period is 8 years. If your turnover exceeds 40 lakhs or your contribution exceeds 25 lakhs, then audit is required. Otherwise, audit is not required. Then statement of accounts and solvency. They ask usually questions on this. Statement of account and solvency shall be prepared within 6 months from here, and you have to file it within 30 days thereof in Form 8 plus prescribed fees. ये फॉर्म वगैरह चेक कर लीजिएगा सेम है या कुछ चेंज तो नहीं हुआ. एनुअल रिटर्न शैल बी फाइल्ड विद इन 60 days of the financial year. end. ठीक है, in form number 11 plus prescribed fees. If there is any violation, then LLP and all designated partners are liable. Section 69, it permits for late filing with late fees. ठीक है, within 300 days of last date of filing with additional fees of 100 rupees per day. ठीक है, for the period of delay, and after expiry of 300 days, you can file it with additional fees without prejudice to any other action or liability. Winding up of this LLP. Winding up of LLP में क्या है? It can be done voluntarily or as per the instructions of the tribunal. Under following circumstances, LLP will be wound up by the tribunal. When LLP decides so, partners are below 2 numbers for more than 6 months. If it is unable to pay its debts, if it is going to affect the integrity, interest of the sovereignty or security of state or public order, if there is a default in filing of statement of account or annual return for a consecutive period of 5 years, or tribunal feels that it is just and equitable to wound up the LLP. ठीक, तो ये कुछ प्रोविजंस थे LLP से रिलेटेड. ठीक है, हमने एक वी आर जस्ट डूइंग ए स्केची डिस्कशन टुडे सो दैट यू बिकम अवेयर अबाउट द वेरियस लॉज. ठीक है, यू कैन रिस्ट्रिक्ट इट हियर ऑल्सो. अब एग्जाम डेज में कम से कम इतना तो पढ़ ही लेना है आपको, बिकॉज लॉट ऑफ लॉज आर देयर, है ना. और बाकी डिटेल्ड प्रेजेंटेशन तो हमने पहले ही आपके साथ शेयर की हुई है, दोबारा भी शेयर कर देंगे. इंडियन पार्टनरशिप एक्ट. पार्टनरशिप एक्ट में क्या है देख लेते हैं थोड़ा थोड़ा. तो 2 or more persons, if they agree to carry on business to share profit, and the business can be carried on by all or any of them acting for all. ठीक है, मैक्सिमम नंबर ऑफ पार्टनर्स कितने हो सकते हैं? एज पर 50 हो सकते हैं एज पर सेक्शन 464 ऑफ कंपनीज एक्ट. म्यूचुअल एजेंसी मींस वन एक्टिंग फॉर द अदर. तो देयर इज अ प्रिंसिपल ऑफ म्यूचुअल एजेंसी. ठीक है, एलएलपी में म्यूचुअल एजेंसी वाला प्रिंसिपल नहीं है. ठीक है, क्योंकि वहां क्या है? कॉर्पोरेट पर्सन है. यहाँ पर क्या है? पार्टनरशिप है, जो लाइबिलिटी इज जॉइंट एंड सेवरल. ठीक है, so everybody is principal, everybody is agent, plus sharing of profit. Mutual agency is main criteria for partnership. ठीक है, and if the partnership is only for sharing of profit, then it is not partnership, except in case of partnership with a minor. What are the characteristics of partnership? 2 or more partners, unlimited liability. Liability is joint and several, and unlimited liability. ठीक है, voluntary registration. Voluntarily you can register yourself, or it can be unregistered partnership also. कोई दिक्कत नहीं. There is no separate legal existence apart from the partners. There is a restriction on transfer of interest. Partners are competent to contract except minor with consent of all the partners. Or it can be formed only for lawful object, and it can be based on agreement. Types of partnership: partnership at will, partnership for fixed duration, partnership for a particular period or object. Types of partners: active or ostensible partner, sleeping or dormant partner, nominal partner, who has been inducted on the basis of his goodwill, so that people think that he is a partner, so more business will come. So he is such a partner is known as nominal partner. Partner in profit only, normally minor. Incoming or outgoing partner, partner by holding out or by estoppel. You are sitting in a conference. One partner says to the public that he is also our partner, although he is not a partner. So, and that partner also doesn't say anything. So such partner will be considered as partner by holding out or by estoppel, because he is representing to public that he is a partner. Then sub-partner. One partner delegating his authority to another person. So that is the concept of sub-partner. Admission. Admission में क्या है? Consent of all the partners is required. And liability of new partner starts from the date he is admitted, unless he agrees for past liability with the consent of the creditors. ठीक है, suppose if A and B were old partners and C was admitted with past liabilities, then also creditor cannot demand from C. ठीक है, पहले पुराने पार्टनर थे A और B, नया C इंडक्ट हुआ, उन्होंने कहा भाई मैं पास्ट के लिए लाइबिलिटी दूंगा, तो क्रेडिटर डायरेक्टली उससे डिमांड नहीं कर सकते. क्रेडिटर्स कैन डिमांड ओनली फ्रॉम A and B. And in turn, जो A and B है, they can ask from C. ठीक है, retirement of partner. So partner can retire by consent of all partners if there is any express agreement, or with notice to the other partners if partnership is at will. ठीक है, so retiring partner is not discharged from the old liability unless continuing partners agree with the creditor and now reconstituted firm execute contract with the creditors that okay, this partner will no longer be liable for the past liabilities. ठीक है, or till public notice is given, he will continue to be liable. Suppose a person deals with the firm and he was not aware that the retiring partner was in the firm, then in such case retiring partner is not liable. ठीक है? And notice can be given by retiring partner or continuing partner. Expulsion of partner. This is an important concept, and sometimes case studies are framed on this. That who can be expelled from the partnership. So expulsion provision must be mentioned in the agreement. Consent of majority of the partners is required. It should always be done in good faith. It's not that two partners agree and they expel without any valid reason. So it must be in the interest of the firm. He should be given notice for expulsion. Opportunity of being heard must be given, else expulsion is null and void. So there was a case study once that, okay, there was a fight between the wives of the partners in a club, and two partners expelled the third partner. So it was not in the interest of the firm. It was not for business purposes. Okay, no? So such an expulsion can be held to be void. So opportunity of being heard must be given, else expulsion is null and void. And it is, and firm can continue despite expulsion if it is at will. Insolvency of partner. If there is any insolvency of partner, then he cannot continue as partner. He will cease to be a partner from the date of the order of the insolvency. His estate is not liable for any act done by the firm after the date of the order. Firm is also not liable for any act done by him after the date of the order. And if rest of the partners agree to continue firm, then they can do so. Regarding death of the partner, in general, firm gets dissolved on death of any partner. Now, but suppose in agreement you have provided that the firm can continue, but minimum number of partners should not go below 2. Suppose there are 2 partners only, one dies, so then firm will automatically get dissolved. But if there are 3 and there is an agreement that, okay, firm will not be dissolved even despite the fact of death of the partner, then the firm can continue. In case of death, no public notice is required to be given. Regarding the minor partner. So during the age on minority, he can be admitted only for profit, not for loss. He is entitled for profit and property. He has got the right to access to books of accounts. He is not personally liable, but his profit and property in firm is liable. He can file suit against firm for profit and property, but not vice versa. Okay? थोड़ा सा disturbance.
Okay, when I have attempted for this exam on 29th April, this retirement and expulsion has been given for 6 marks, sir.
हाँ, वो तो केस स्टडी है ना, केस स्टडी कहीं पे भी आ सकती है.
Yeah.
क्या था क्वेश्चन आपका?
This retirement and expulsion.
ओके, पार्टनरशिप पे स्टडी था कि क्वेश्चन था?
No, case study only. Case study
कोई
only.
केस स्टडी जैसे मैंने बताया ना, कर लेते हैं भाई, एक्सपेल किसी पार्टनर को एक्सपेल कर दिया. मान लीजिए 3 पार्टनर्स हैं, अब वो कहीं क्लब में गए, उनकी वाइफ्स के बीच में लड़ाई हो गई, 2 पार्टनर ने जो है एक पार्टनर को एक्सपेल कर दिया.
Almost similar.
है ना? हाँ, वो ऐसी ही केस स्टडी आती है. हाँ जी. तो
Sir, I think you can start the recording.
हाँ जी,
I think you can start. Recording is on. Okay, okay.
नहीं, रिकॉर्डिंग इज ऑन. ठीक है, रिकॉर्डिंग तो है ना. माइनर पार्टनर. ये मेरा स्क्रीन तो नजर आ रहा होगा आपको.
अरे सर,
Yeah, now it came, sir. Now it came.
हाँ, थोड़ा सा बीच में डिस्टर्बेंस हो गया था. हाँ. So after
This
attaining
is
the
also
age of
very
majority,
important concept.
a public notice should be given by him within 6 months. And if he fails to give public notice, then he automatically will be treated as continuing partners. Okay? Now there could be 2 options. He may accept to continue as partner. He may not like to continue as partner. Suppose he decides to continue as partner. So he will share same position as other partners. He will be personally liable from the date of admission to the benefits of partnership, and share of profit and property same as before. If he doesn't accept to continue as partner, then liability is same as before. Okay? He is not liable for any further liabilities, and he can take his share of profit and property, else he can sue the partners for taking out his share. Insolvency, ये तो हो ही गया. माइनर पार्टनर चाहिए होगा. नाउ डिसोल्यूशन ऑफ फर्म. डिसोल्यूशन ऑफ फर्म में क्या है? वॉलंटरी डिसोल्यूशन है, कंपल्सरी डिसोल्यूशन है, डिसोल्यूशन ऑन हैपनिंग ऑफ सर्टेन कॉन्टिजेंसीज. So voluntary dissolution. So voluntarily, the firm may be dissolved as per the mutual agreement with consent of all the partners or as per the contract. Suppose it was formed for a specific duration. Then compulsory dissolution on happening of certain events. Or like I told you, two partners are there, one dies. So compulsorily it has to be dissolved. Object becomes unlawful. If the firm has more than one object, then which is lawful, that with that they can continue. Okay. Section 42 on happening of certain contingencies. If it is made for fixed term or period. If it is made for specific adventure or project. So adjudication of partner as an insolvent unless remaining partner wants to continue. Section 143 partnership at will. So if the partnership is at will, any partner can give notice for dissolution and it will be dissolved from the date mentioned in the notice or date on which communication is complete. Okay. Dissolution of firm on order or the court. If there is an insanity or unsound mind of the partner other than the sleeping partner, if there is permanent incapacity of the partner, misconduct, persistent breach of contract, embezzlement, keeping erroneous accounts, holding more cash in hand, if he refuses to show account on repeated request, okay, transfer of interest, continuous or perpetual loss, where it cannot be business cannot be carried on except at a loss, or if it is just and equitable, कोई deadlock हो गया management में, they are not on talking terms, loss of substratum, okay, goal is missing, or gambling by partner. So all these are the cases where the firm can be dissolved as per the orders of the court. Registration of firm. Registration of firm is voluntary. You can, you may not register. At any time you can register. At the time of forming the partnership or thereafter also. Application has to be signed by all the partners or the authorized representatives. Statement should be required to verify and signed by all. On satisfaction by the registrar, it will make entry in the registrar form and issue certificate of registration. Okay. Now, what are the consequences of non-registration? So, partner or firm cannot file civil suit against third party for recovery. Okay. No relief to partner for set off of claim. So, maximum rupees 100 up to rupees 100 you can claim set off, otherwise not. Okay. Aggrieved partner cannot take legal action against other partner or the firm because as per law the existence is not there. But third party can sue the firm or partner, although it is not registered. Okay. Now let us see some of the provisions of RERA. Important definitions. ये LLP लिख दिया, RERA होना चाहिए यहाँ पर. The promoter, selling agent, allottee, carpet area, common area, commencement certificate, occupancy certificate. Okay. Registration of project. Registration of project is compulsory. So project is compulsorily, it has to be registered before making any invitation or advertisement to sell. Okay. Following projects are not required to register if plot area is less than 500 square meter. Basically, ये जो इंडिविजुअल अपना मान लो अपना मकान बना रहे हो तो उस केस में रजिस्ट्रेशन जरूरी नहीं, ठीक है ना. अपार्टमेंट इज लेस देन 8, कंप्लीशन सर्टिफिकेट इज रजिस्टर्ड फॉर रिपेयर एंड रिनोवेशन और रीडेवलपमेंट. If project is phased manner, then need to count all and then it will be registered. For registration, application form है plus prescribed fees plus attachments plus declaration and affidavit. ठीक है. Old project but not completed till date of act came into existence, then such project is required to be registered within 3 months. Now, what are the documents to be attached for application for registration? इसको याद करने के लिए क्या है, पागल केब्ड. ठीक है. P से प्लान बन जाता है आपका. A हो गया आपका अपार्टमेंट, G से गैराज, A से एजेंट्स, L से लोकेशन बन गया, C से बन गया कॉन्ट्रैक्टर, A से बन गया आर्किटेक्ट, P से हो गया पास्ट प्रोजेक्ट्स एक्सिक्यूटेड इन 5 years, E से बन गया एंटरप्राइज और D से बन गया डीड. ठीक है. तो ये चीजें आपको देनी है. डिक्लेरेशन एंड एफिडेविट. डिक्लेरेशन एंड एफिडेविट में क्या आएगा, आपका टाइटल ऑफ द लैंड. It has to be free from encumbrances, project completion period. 70% of the amount collected from allotee to be kept in scheduled bank account. Okay? And it can be used only for project purposes. Withdrawal of such amount is allowed only for land and construction cost, subject to certificate issued by engineer, architect and chartered accountant. 30% can be used for administrative purposes. Such account is required to be audited by practicing chartered accountant within 6 months of the financial year end, and also need to certify that the amount withdrawn is used for the same purpose. Okay. Now, grant of registration certificate. On satisfaction of the application, registrar will issue the registration and provide registration number. Within 7 days of registration, login ID and password will be issued. If registrar has not issued registration or rejection order within 30 days, then it is deemed registration. Okay. Before rejection of application, opportunity of being heard will be provided to you. In registration period, also will be mentioned for the validity of registration as mentioned by the promoter in the application, that for what period it is applicable. Suppose there is an extension, your project gets extended. It was initially for a period of 5 years, but now it gets extended. So extension to complete the project can be given only for force majeure, and maximum period is 1 year. And you have to pay additional
Sir,
fee.
sorry to interrupt.
Yes, please.
Sir, is there any specific, what is the specific criteria for audit as regards turnover and based on form of organization? This
नहीं, फॉर्म ऑफ
RERA
ऑर्गेनाइजेशन
में?
में तो फिर कंपनीज एक्ट में तो देखो ऑडिट कंपलसरी है ही आपका। एलएलपी का हमने बता दिया 40
बराबर।
करोड़ की टर्नओवर है, और अपना 25 करोड़
हाँ।
की अगर आपके बेटा कैपिटल है तो 40 लाख और
ओके
25 लाख, इस तरह से।
ओके ओके
वो तो आपका
ठीक है,
ऑर्गेनाइजेशन
ओके।
वाइज है।
हम्म
फिर इनकम टैक्स में टैक्स ऑडिट वाला प्रोविजन है, वो एक अलग चीज है, उसको अलग से कहीं कर सकते हैं आप। ग्रुप में लिख दीजिएगा, वी विल डिस्कस दैट।
ओके
यहाँ पर क्या है, यहाँ पर तो ये है ना बेसिकली कि आपको चार्टर्ड अकाउंटेंट से सर्टिफिकेट लेना है, ठीक है ना, फॉर यूटिलाइजेशन।
या
Now, what are the functions and duties of the promoter? You have to create a web page and you have to mention all the details of the project. ये जो अथॉरिटी होगी, रेरा अथॉरिटी, वहां पर एक वेब पेज क्रिएट किया जाता है और सबको लॉगिन आईडी और पासवर्ड देते हैं। आफ्टर कंप्लीशन ऑफ प्रोजेक्ट विद इन 5 years, if any structural defect is there, then the promoter has to rectify the same. Now, transfer of title. On completion of the project, conveyance deed will be executed and physical possession will be handed over to the allotee. ठीक है। और जो ओपन स्पेस है या जो कॉमन एरिया, उसके लिए एसोसिएशन ऑफ अलॉटीज बना देते हैं, ठीक है। रिटर्न ऑफ अमाउंट एंड कंपेंसेशन। सो व्हाट आर द सर्कमस्टांसेस वेयर यू टू रिटर्न द मनी, ठीक है। सपोज प्रोजेक्ट इज नॉट कंप्लीटेड और पोजेशन इज नॉट गिवन, ठीक है, और देयर इज डिसकंटिन्यूएंस ऑफ द प्रोजेक्ट और रजिस्ट्रेशन इज रिवोक्ड, ठीक है। And if the allotee wishes to withdraw, then whole amount along with interest will be given. If allotee does not wish to withdraw, the interest will be paid on a monthly basis of delayed period till handing over of the possession. तो ऐसा है, मान लीजिए शेड्यूल्ड पोजेशन था आपका विद इन 3 years, बट नाउ दे आर नॉट विलिंग टू गिव। अब दो बातें हो सकती है, अलॉटी का भाई मेरा पैसा वापस कर दो, तो पैसा वापस करना पड़ेगा। अगर पैसा नहीं देना तो आपको फिर इंटरेस्ट देना पड़ेगा ऑन अ मंथली बेसिस। In case of defective title, then promoter will compensate to allotee and will recover from insurance company. Establishment and terms of regulatory authority. So this authority has to be established within 1 year of this act. So 2 or more states can keep one regulatory authority because it is state-wise. ठीक है, यूपी रेरा, एमपी रेरा, इस तरह से। तो one state can have multiple regulatory authorities also. So body corporate status is being given to RERA, perpetual succession, common seal. Maximum term is 5 years or till the attain of 65 years, whichever is earlier. ये member के लिए, ठीक है। No reappointment. Before appointment of chairperson or member, government will check that financial or other interest should not affect prejudice to their duty or functions. Now suppose RERA authority has given any order and you want to appeal to the tribunal, ठीक है ना, appellate tribunal. So appeal from appellate tribunal to high court, it should be filed within 60 days, ठीक है, plus another 60 days can be granted, and 10% of the project cost will be levied as penalty to promoter for non-registration of the project. Securitization and reconstruction of financial assets. एक टाइम देख लेते हैं क्या हो गया, अभी तो टाइम है, तो अभी कुछ वैसे जनरल डिस्कशन कर लेते हैं, है ना, या रेरा कवर कर लें।
पार्टनरशिप पे अगर 2-3 केस
हाँ,
स्टडी कर सके
पार्टनरशिप पे बिल्कुल कर लेते हैं, बिल्कुल बिल्कुल बिल्कुल, ठीक है। तो ये जो है, एक मिनट, मैं पार्टनरशिप पे डिस्कस कर लेता हूँ।
कंपनी जब कहे कंपनी जब पे भी कर सकते हैं, बट एवर।
हम्म। एक मैं जरा ये शेयर करता हूँ illustration case studies. Retirement apartment, basement. Indian Contract Act. ये देखते हैं केस स्टडी, ना रिटायरमेंट ऑफ ए पार्टनर, ये अलग है, ये अलग है, एक्सपल्शन ऑफ ए पार्टनर। ये नजर आ रही होगी मेरे ख्याल केस स्टडी आपको।
जी सर।
हाँ, तो इसको एक बार देख लेते हैं क्या है। Suncare Food Products and Services is a partnership firm engaged in the business of food products and services, having 14 partners. The firm is not registered. ठीक है, तो आपको दो तीन बातें ध्यान में रखनी है। पहली बात तो इट इज नॉट रजिस्टर्ड। फर्म इज कंसिडरिंग द एक्सपल्शन ऑफ द फॉलोइंग पार्टनर्स फ्रॉम द फर्म। ठीक है, Sudha Chandran is alleged to be guilty of fraud into the business by corrupting the data related to stocks available with the firm. It has come to the notice of the firm that stock figures are tampered with a view to understate the profit, and thereby the partner is guilty of breach of trust to the partners of the firm. Also, some of the invoices regarding goods purchased have not been recorded into the stock register maintained for the said purpose. Stock quantity underlying into the godown of the firm also do not match with that of the figures as stated in the stock register. Ravichandran is alleged to be guilty of unsound mind as he entered into a quarrel with the other 5 partners of the firm in a public place. FIR regarding the said quarrel was filed in the nearby police station, and the police took away the Ravichandran into his custody, and it is only after that he got bailed on a bail given by a relative of Ravichandran that he could be released from the police custody. He stayed in the police custody for 2 days. Dinanath, an aged partner of the firm, lost all of his family members in the COVID pandemic prevailing in the country and becomes of unsound mind due to this fact. He is of the age of 93 years as on that date and is undergoing a treatment in the Apollo Hospital, Delhi for the said cause. You are appointed by the firm to examine the position of the firm regarding the expulsion of the above partners from the firm under the various provisions of the partnership. ठीक है, ये 3 पार्टनर है, एक ने क्या किया, एक ने फ्रॉड किया, दूसरे ने क्वारल किया, ठीक है, अब अनसाउंड माइंड का है, और तीसरा जो है वो उसमें भी क्या है, वो भी अनसाउंड माइंड का है। नाउ फर्स्ट क्वेश्चन, कैन सुधा चंद्रन, रविचंद्रन, दीनानाथ बी एक्सपेल्ड फ्रॉम द फर्म? हो सकते हैं, नहीं हो सकते? हाँ जी,
नो सर,
है,
नहीं हो सकते सर।
नहीं हो सकते, क्यों? नहीं, कोई अनसाउंड माइंड का हो गया, आप उसको हटा नहीं सकते?
दो अनसाउंड माइंड एंड
जो फ्रॉड किया
द
जिसने,
पर्सन हुआ जिन्होंने फ्रॉड किया, उन दोनों को हटा सकते हैं सर। लड़ाई झगड़े वाला भी
सर पर फर्म का डिसएडवांटेज कहाँ कर रहे हैं
है,
एक्सेप्ट फॉर
फ्रॉड,
सर?
जिसने
वो
फ्रॉड किया।
प्रीवियस स्क्रीन पे लीजिए ना सर, एक
ये
बार।
लीजिए, हाँ, ये नजर आ रही है ना?
तीनों को हटा सकते हैं सर।
हम्म। भाई एक क्या कर रहा है, एक फ्रॉड कर रहा है, वो डेटा को
एक
फर्जी
लड़
कर
रहा
रहा
है।
है, दूसरा अनसाउंड माइंड का है, ठीक है ना, और तीसरा जो है वो भी एज्ड है और अनसाउंड माइंड। What majority of
एक
members
लड़
is
भी तो रहा है।
required in the said case to expel Sudha Chandran, Ravichandran, Deenanath from the firm? क्या मेजोरिटी चाहिए, मतलब कितने पार्टनर है, पहले तो ये देख लीजिए, पार्टनर है 14, ठीक है,
14 पार्टनर
कितने
है।
पार्टनर एक्सपेल कर सकते हैं? ये तो हमने देखा था ना, अभी मैं दूसरी केस स्टडी भी शेयर करता हूँ साथ साथ में आपके पास। ये है ना एक्सपल्शन, एक्सपल्शन में क्या है, ये नजर आ रहा होगा आपको स्क्रीन,
जी सर, जी सर।
है ना? हाँ, एक्सपल्शन में क्या है, पहले एक्सपल्शन के प्रोविजन देख लेते हैं। एक्सपल्शन प्रोविजन मस्ट बी मेंशन्ड इन द एग्रीमेंट, कॉन्सेंट ऑफ मेजोरिटी ऑफ द पार्टनर्स इज रिक्वायर्ड, मतलब सिंपल मेजोरिटी चाहिए, जैसे 14 है तो 8 हो
सिंपल
जाएंगे,
मेजोरिटी।
ठीक है ना। इट शुड बी
जी।
डन इन गुड फेथ, expulsion must be in the interest of the firm, he should be given notice for expulsion, opportunity of being heard must be given, else expulsion is null and void, and it is not dissolution of the firm can continue if it is at will। तो ये एक्सपल्शन ऑफ पार्टनर की कुछ कंडीशंस है जो हमने पढ़ी थी, ठीक है। अब हम दोबारा चलते
सब
हैं।
इसमें क्वेश्चन, सब
हाँ,
इसमें अब इसमें क्वेश्चन ये है कि जो जिस पार्टनर को एक्सपेल कर रहे हैं उसका वोट भी होगा।
है, उसका
द
उसको
पार्टनर
अपॉर्चुनिटी
हु
देंगे
इज
हम तो, उसको तो अपॉर्चुनिटी देंगे ना, उसको अपॉर्चुनिटी ऑफ
राइट।
देंगे, बस ये है।
Sir, 6 partners should make the majority of the.
हाँ तो सर 14 में से 3 निकल गए जिनके अगेंस्ट केस है।
11 हो गया तो 6 partners I think should.
सर पर एक्सपल्शन इंडिविजुअल केसेस के बेसिस पे होगा कि ऑल 3 एक ही टाइम पे निकाले जा रहे हैं, सो देन द पार्टनर्स का नंबर्स का रेशियो चेंज हो जाएगा।
Sir, usually the
पहले क्वेश्चन देख लेते हैं,
expelling
पहले सारे क्वेश्चन देख लेते हैं, फिर डिस्कस करते हैं।
Yes.
expelling partners will not be counted, sir.
तीसरा देखते हैं, एक क्वेश्चन देख लेते हैं, लेट अस सी द फर्स्ट क्वेश्चन देन विल डिस्कस। कैन द मेंबर्स हु आर एलिज्ड टू बी गिल्टी ऑफ एनी अदर मिसकंडक्ट वोट ऑन द रेजोल्यूशन रिगार्डिंग एक्सपल्शन? ये वो वाला क्वेश्चन आ गया आपका कि भाई ये जो 3
यस।
पार्टनर है क्या इनका भी वोट होगा, नहीं होगा? व्हाट विल बी द लीगल पॉइंट इन द
No,
सेट केस इफ द फर्म इज अ रजिस्टर्ड फर्म regarding members consent for expulsion of partner? What shall be the procedure regarding expulsion of the alleged members in the above case? ठीक है, तो एक्सपल्शन ऑफ पार्टनर का क्या क्या प्रोविजंस है इसमें? पहला बात तो ये है कि दे कैन बी एक्सपल्ड, देयर इज नो डाउट अबाउट इट, एक्सपेल तो हो ही
यस।
सकते हैं, है ना, इसमें तो कोई डाउट
Right.
नहीं है, किसी को
If
डाउट नहीं होना चाहिए। दूसरा ये
Right.
मेजोरिटी कितनी चाहिए। मेजोरिटी में बात क्वेश्चन ये उठता है कि all 14 will be counted for the purpose of majority or 3 will be excluded. That is the basic question.
Yes. Yes.
3 will be excluded, sir.
हाँ, yes. So majority आपकी रहेगी, आप समझिए more
Six,
than
what,
more than 50%
Six.
of 11. More
Yes.
than
6.
more than 50% of 11.
11.
14
Six.
minus 2, है ना, यही रहेगी ना।
जी सर।
Yes, sir.
Can the members who are alleged to be guilty of any other misconduct vote on the resolution?
No.
No.
ये तो वोट नहीं कर पाएंगे। What will be the legal
No,
point in
sir.
the said case if the firm is a registered firm regarding members' consent for expulsion of a partner? इससे कोई फर्क पड़ेगा क्या, रजिस्टर्ड है या अनरजिस्टर्ड है?
No difference, sir. No.
है ना,
No difference.
इसमें कोई नो डिफरेंस है, ठीक है। क्योंकि वो तो क्या है, बेसिकली इट टॉक्स ऑफ लायबिलिटीज। If the
Right.
firm is unregistered, then you cannot take action against the other partners or you cannot
Other
recover the
partner.
money, है ना। No set off is allowed except 100 rupees, इतना है। But the creditors can sue your partnership firm or partners. ये है unregistered का। What shall be the procedure regarding expulsion of the alleged members in the above case? अब आप क्या करोगे?
Meeting of partners.
अब now it will depend upon the facts whether it is a registered firm or unregistered firm, ठीक है। अगर रजिस्टर्ड फर्म है तो क्या है, यू विल इन्फॉर्म द रजिस्ट्रार ऑल्सो आफ्टर पासिंग दी
Right.
वोटिंग के बाद में। और अगर अनरजिस्टर्ड फर्म है तो इफ इट इज ए पार्टनरशिप डीड तो देन यू विल रिकंस्टिट्यूट द फर्म आफ्टर एक्सपेलिंग दीज पार्टनर्स,
Right.
है ना। तो दैट विल डिपेंड अपॉन द फैक्ट्स एंड सर्कमस्टांसेस ऑफ द केस। तो पार्टनरशिप डीड भी आपको दोबारा बनानी पड़ेगी नेचुरली, है ना। प्रॉफिट शेयरिंग रेशियो भी
Okay.
चेंज हो जाएगी आपकी। और अगर रजिस्टर्ड है तो आप रजिस्ट्रार को भी इन्फॉर्म कर दोगे। आप इनको अपॉर्चुनिटी ऑफ बीइंग हर्ड दे सकते हो, ठीक है, यू कैन गिव देम अपॉर्चुनिटी ऑफ बीइंग हर्ड। अगर कोई अनसाउंड माइंड का है तो उसका लीगल रिप्रेजेंटेटिव होगा या कोई लीगल हेयर होगा या उसका जो भी है कोई बेनिफिशियल ओनर है उसको भी आप अपॉर्चुनिटी ऑफ बीइंग हर्ड दे सकते हो, उससे आप कंसेंट ले सकते हो।
Right, sir.
But one second, sir.
यस,
If it is not a registered firm, then the majority members expelled the persons who have done the fraud or mistake.
यस,
Then they either the unregistered firm or that people who were expelled, they cannot file any cases against each other.
हाँ बिल्कुल, बिकॉज इट विल नॉट, इट इज नॉट रिकॉग्नाइज्ड बॉडी ना।
The unregistered effect is that
हाँ,
only, na?
बिल्कुल 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 ठीक है। अब ये देखते हैं रिटायरमेंट ऑफ ए पार्टनर। रिटायरमेंट ऑफ पार्टनर में क्या है, मून प्रोडक्शन सर्विसेज पार्टनरशिप फर्म एंगेज इन द बिजनेस ऑफ मैन्युफैक्चरिंग इलेक्ट्रॉनिक आइटम्स। इसमें 4 पार्टनर्स है, शशिकरण, चंद्रप्रकाश, सोमदत्त एंड चंद्रशेखर। फर्म इज ए रजिस्टर्ड फर्म अंडर द पार्टनरशिप एक्ट। As per the partnership deed, all the partners are entitled to share the profits of the partnership in the proportion of their capital contribution, ठीक है। 2, 5, 10 और 3 ये रेशियो है इनका, ठीक है। In the year 2022, सोमदत्त expressed his willingness to retire from the firm. पहली बात क्या है, ये जो है रजिस्टर्ड फर्म है, ठीक है। और इनका प्रॉफिट शेयरिंग रेशियो क्या है, 2, 5, 10, 3। In the year 2022, Somdath expressed his willingness to retire from the firm as he is of the age of 67 years as on that date, and also due to the fact that the family members of him are settled abroad and he wants to spend the rest of his life along with his family members, ठीक है। However, the remaining partners of the firm think that the retirement of Mr. Somdath as such would amount to heavy losses for the firm and it would at most become difficult to continue the business of the firm, ठीक है। उसकी गुडविल है काफी। In order to mitigate the losses of the firm, they want to continue the business firm as a going concern in future, ठीक है। Above all, the firm do not have enough funds to pay the share of Mr. Somdath. उसके पास पैसे भी नहीं है फर्म के पास उसको देने के लिए। After negotiations, the following draft of retirement of Mr. Somdath came into existence. So propose that share of capital of Mr. Somdath in the firm shall be transferred to his loan account, ठीक है। So this is regarding conversion of capital into loan account and he will be entitled to an interest at the rate of 18% on the loan amount standing to the credit of his account. Proposed that Mr. Somdath shall be entitled to rent of 20,000 per month in respect of his property in which the registered office of the firm is located, provided the said property is given on lease to the firm for a period of 20 years. The firm is paying rent at the rate of 12% per 12,000 per month at the time of retirement of the partner. Mr. Somdat had an undischarged liability of rupees 1 lakh in respect of claims admitted by him to be paid by or on his behalf in near future. The firm admits to discharge the said liability. अब इस केस में हम first of all whether this such sort of agreement can be entered into by the firm. So this question is based on the consequences of the retirement from the partnership firm. So retirement of a partner need not necessarily result in dissolution of the firm. ठीक है ना?
Right.
तो पहली बात तो ये है, आप ये चाहते हैं भाई सोमदत्त जो है, सोमदत्त को देने के लिए पैसे भी नहीं है इनके पास, तो ये क्या करें कि इसको इसके अकाउंट जो है हम लोन अकाउंट में कन्वर्ट कर देंगे, ठीक है, और उस पर
कर सकते हैं सर।
हम इंटरेस्ट दे देंगे, ठीक है, तो कोई दिक्कत नहीं है इसमें। और एग्री ये जो है
कर सकते हैं।
अब ये कहते हैं इसको रेंट देंगे 20,000 पर मंथ in respect of the property for a period of 20 years. The firm is paying rent at the rate of 12,000 per month.
A settlement of the retiring partner.
है?
This is nothing but consideration
No.
for retirement of that partner.
No. It is not consideration. This is
Yes,
for use of the registered office.
Yes.
The firm. That
Use
is
of
owned
the-
by someone.
हाँ,
ये भी कर सकते हैं सर, ये भी कर
हाँ।
सकते हैं।
और ये जो अनडिस्चार्ज लाइबिलिटी है, फर्म कहती है कि भाई हम ये लाइबिलिटी ओन कर लेंगे,
Yeah.
तो दे कैन डू सो, इसमें कोई इशू नहीं है।
They
They
can
can
do.
do so. They can do so, sir.
अच्छा, केस स्टडी ऑन माइनर एज ए पार्टनर. Monu Sood is an industrialist. Monu Sood is running a partnership firm by the name of Sood and Company. His son Sachin was inducted as a partner in his family business without his knowledge. भाई क्या होता है, बच्चों को कह देते हैं पेपर साइन कर दो या उनको पार्टनर बना देते हैं विदाउट देयर नॉलेज, उसको नहीं पता, ठीक है. So there can be a situation where a minor is admitted to the benefits of the partnership without his knowledge. ठीक है. अब उसमें liability कब arise होती है? When this fact comes to his knowledge. The consent of all the existing partners was obtained before induction of Sachin as a partner. ठीक है. A sum of rupees 10 lakh was introduced as capital by his father and Sachin was entitled to 5% of the profits generated by the firm. ठीक है. Unfortunately, Monu Sood was killed in an accident. ठीक है. In the meantime, the firm's business was badly hit due to pandemic and it was unable to service the debt taken by the firm. Mr. Roshan Lal, a supplier of material to Sood and Company, had supplied material worth rupees 40 lakhs to the firm. Roshan Lal gave a notice of 14 days to make the payment, failing which he will file a petition under IBC. The firm raises a plea that the material supplied by the firm was defective and they will not pay for the same. However, the material was sold to another supplier by Sood and Company for 50 lakhs. Okay? And the amount was realized from the purchaser. Mr. Roshan Lal comes to know that Sachin is also a partner and he has not given a public notice whether he elects to become a partner or not. In view of these facts, please answer the following question. Because when a minor, it comes to his knowledge, so he has to give a public notice whether he wants to continue on attaining majority. If he doesn't give any public notice within 6 months, then he is deemed to be a partner and he is liable. For the ex prior to his admission as a partner on attaining majority, his property in the firm is liable. So first question is whether Sachin can be held liable since he failed to give public notice after attaining majority. Already more than 6 months have elapsed since he attained a majority. तो क्या सचिन को लायबल कर सकते हैं या नहीं कर सकते?
He is liable, sir.
Yes.
He is liable, sir.
Yes, because after attaining majority, it is his duty to inform.
Duty to.
है ना? If he doesn't inform within 6 months, then he is liable. Can Mr. Roshan Lal directly proceed against Sachin? सचिन के अगेंस्ट में जा
No.
सकते हैं? क्यों नहीं जा सकते?
Sir,
No,
firm
sir.
के against जा सकते हैं,
It
सचिन
was
के
not notified for partnerships. Partnerships and individuals.
Individuals.
बिल्कुल ठीक है. What shall
Sachin
be
is a
his,
partner of the
हाँ.
firm, yeah.
हाँ, what shall be his share in the property and profits of the firm? अब इसका जो शेयर है वो क्या होगा?
इसके फादर का ऐड करके दोनों का मिला के हो जाएगा सर.
In ratio of his capital,
In
sir.
the ratio of his capital.
not for the father's share.
फादर का
Sachin,
शेयर भी इसी को आएगा दोस्त.
Sachin gave
नहीं
an
सर, वो तो
argument.
डिसीज पार्टनर का लायबिलिटी खड़ा होगा फर्म में.
फादर
फादर का शेयर तो फादर
Sachin
का
gave-
शेयर जो है वो
हाँ
डिसीज पार्टनर लायबिलिटी होगा
हाँ,
फर्म में.
वो
दैट विल
लाइबिलिटी आ
नॉट
जाएगा. हाँ
गेट.
बिल्कुल ठीक है. वो लोन अकाउंट में कन्वर्ट कर दो या पार्टनर लाइबिलिटी में कर दो. Sachin gave an argument that he was not aware about the fact that he was a partner in the firm, so then company. At the most, he can be held liable to the extent of his capital contribution in the firm and not beyond that. Is his argument tenable?
Sir, clubbed with question 1, the argument is not tenable. If
Yes.
he is
Actually,
attained the majority.
This
and-
argument is tenable only when he decides not to become a partner and he gives a public notice within 6 months. ठीक है, मतलब
Okay,
there will be
yes.
two situations. Number one, he gives a public notice within 6 months that he doesn't want to become a partner. ठीक है ना. तो उस केस में क्या होगा, जो उसकी प्रॉपर्टी इन द फर्म है, ओनली टू दैट एक्सटेंट ही कैन बी हेल्ड लायबल. उसके लिए तो लायबल हो ही सकता है वो, ऐसा नहीं कि उसके लिए लायबल नहीं होगा. अब उसकी कैपिटल भी है ना 10 लाख रुपए फर्म में.
सर एक और चीज होगा ना, if he that 6 months has not elapsed from the majority, तब भी वो अपना कैपिटल का शेयर का ही लायबिलिटी लेगा.
यस, बिल्कुल बिल्कुल बिल्कुल. हाँ, सुधा ए माइनर वाज एडमिटेड इनटू द पार्टनरशिप इन द ईयर 2020. इसको ना थोड़ा सा और ग्रुप में भी डिस्कस कर सकते हैं. ये केस स्टडीज एक बार आप पढ़ लीजिएगा आराम से, ग्रुप में भी डिस्कस कर लेंगे. वी कैन हैव अनदर क्लास ऑन संडे, है ना.
ठीक है सर.
क्योंकि
सर
ऐसा भी
ये
हो.
एक अलग प्रेजेंटेशन है.
हाँ जी,
ये पार्टनरशिप वाला एक अलग पावर पॉइंट नहीं. अच्छा, ये 1424 वाले में से आप पूछ रहे हैं. ओके.
हाँ वही 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 1424 है. हाँ,
ठीक
सुधा
है, ठीक है.
ये तो है ना आपके पास.
हाँ
है
हाँ
सर, है.
हाँ,
यस.
सुधा ए माइनर वाज एडमिटेड इनटू द पार्टनरशिप. ये लास्ट देख लेते हैं बस. टाइम कितना हो गया, अभी तो है टाइम थोड़ा सा, देख लेते 5 मिनट.
Sir, in earlier question, one doubt, sir.
यस,
I think that minor can take a plea that he doesn't have knowledge. Attaining majority within 6 months, or having the knowledge that he is a partner in that firm, whichever is later, sir. Actually, if he proves that he doesn't have knowledge that he was admitted as partner for the benefits while his minority, then he will not be liable.
actually there are 2-3 things. Number one,
Section 35 is there, Indian Partnership Act.
भाई वो ठीक है, मैं क्या कह रहा हूँ, इसमें क्या है, सबसे पहले तो ये देखना है कि व्हाट इज द मैक्सिमम एक्सटेंट टू विच ही कैन बी हेल्ड लायबल. ही कैन बी लायबल ओनली टू द एक्सटेंट ऑफ हिज कैपिटल कंट्रीब्यूशन. ठीक है. सेकंड बात ये है कि ये 6 मंथ्स का पीरियड कब से देना है. 6 मंथ्स का नोटिस ऑन इज अटेनिंग मेजोरिटी
Or obtaining knowledge.
और when it comes to his knowledge. भाई उसको पता ही
Yeah,
नहीं
whichever is
पार्टनर है, तो
later.
वो तो फिर 6 मंथ्स कब से काउंट करना है आप. 6 मंथ्स आपको काउंट
Yes.
करना है भाई. एज ए माइनर ही मे और मे नॉट बी अवेयर. अगर इफ ही इज अवेयर दैट इज ए पार्टनर, ठीक है, तो देन विद इन 6 मंथ्स ऑफ हिज अटेनिंग मेजॉरिटी ही विल गिव ए नोटिस. बट सपोज ही इज नॉट अवेयर,
Yes, yes.
ठीक है ना, तो दिस 6 मंथ्स विल बी काउंटेड फ्रॉम द डेट ऑफ हिज कमिंग टू हिज नॉलेज. बस यही है. सुधा
Yeah, correct.
हाँ, Sudha minor was admitted into the partnership in the year 2020 with the consent of all the partners. ठीक है. Sudha brought 2 lakh as her capital contribution to the firm and 3 lakh as her loan to the firm. Sudha is a well-known sports person and won many prizes and awards at the national level. Sudha is the daughter of Nirmala Devi, who happens to be the wife of Shashidhar. Sudha was of the age of 16 years while she was admitted into the partnership. ठीक है. The parents of Sudha under an agreement are living separately. Sudha's mother has been appointed as the legal guardian of Sudha by the court. Sudha's mother has recently married with a renowned businessman in the year 2021. The firm pays no interest to Sudha on her loan account. Her share of profit is being transferred to a separate account, especially opened for the said purpose in the SBI. Sudha's mother is the guardian of Sudha in respect of this account, and the amount standing to the credit of this account can be withdrawn only after Sudha attains majority. ठीक है. The amount standing to the credit of this bank account turns out to be 7,50,000. Besides that, Sudha has a separate bank account in Canara Bank in her name, and the amount standing to the credit of the said bank account turns out to be 12 lakh. At the time of liquidation, the age of Sudha was 18 years, 2 months and 11 days. What shall be the status of Sudha as a partner in the firm on the date the firm went into liquidation? The firm is not registered under the Partnership Act. Is the non-payment of any interest on the amount standing to the credit of Sudha loan account justified? Can outstanding credit of 7,50,000 in the bank of SBI and amount standing to the credit of Sudha in Canara Bank be held liable for repayment to creditors in the case of firm's dissolution? Dissolution कर देंगे liquidation के बजाय. Whether the capital contribution of 2 lakhs made by Sudha into the firm may also be held liable in case of firm's liquidation. Who can become the guardian of a minor? In the above case, is the mother of Sudha a lawful guardian? Is the status of Sudha's mother as a guardian remains the same even after her marriage? So these are some of the questions. Okay. So please go through all these case studies and then we can discuss. है ना? So we have tried to form case studies on each and every act. सरफेसी है, जितने भी एक्ट है ना, सबके ऊपर कुछ ना कुछ केस स्टडी बना रखी है और इनकी रिकॉर्डिंग भी है, तो दैट रिकॉर्डिंग ऑल्सो आई विल शेयर.
Right, sir.